Well,
You can present yourself.
thank you very much indeed. It really is a pleasure to be with you this evening. Unfortunately, not in person as had been originally planned, but nonetheless, a pleasure to join all of you at MIFF and revel in the incredible work that you're doing. And I'm very grateful for the invitation. I am a practicing lawyer in London. I also have the great honour to be a director of an organisation called UK Lawyers for Israel, a voluntary organisation of lawyers working really to advance the proper and objective application of law to Israel, citizens of Israel, supporters of Israel. We use the law against attempts to undermine, attack, and delegitimize Israel and Israeli organizations. And one of the areas that UK LFI contends with is misrepresentations of international law vis-à-vis Israel. You'll often hear that Israel violates international law. The accusation is thrown around without basis or justification. But the difficulty, I believe, is that many people don't know very much about international law. It's quite a mysterious concept. And so it can easily be misrepresented in relation to Israel. It's also an area in which politics and law overlap and where a special language of condemnation has evolved in relation to Israel. Illegal settlements, inextricably linked with illegal occupation. These are unique terms in respect of their use to Israel, and they are contrary to what international law actually says. So I've been asked to address the status of Jerusalem and settlements in international law. And over the next 40 minutes, I propose to cover what international law tells us about the legal status of the territory. I'll look in particular at Jerusalem. I'll look also at the settlement issue. And finally, by way of example, I'll look at the recent controversy over Israel's proposal to apply Israeli civilian law to parts of Area C in the West Bank, which has been incorrectly termed annexation. But first, for the non-lawyers in the room, of which I appreciate there must be many, international law is very different to domestic law, with which we're more familiar. There is no international parliament which sets down international law for us all to follow. It's a body of rules that has been established according to a number of key sources, and I'll mention the two main ones. The first is treaty, and that is quite like contract law. So it involves states making written agreements between themselves, bilateral treaties or multilateral treaties if many states join together, or perhaps they sign up to a convention. And that is law that states sign themselves up to and bind themselves to. But another source of international law is custom. Now, customary international law, customary legal principles, they can develop over time, and they evolve when sufficient number of states behave in a particular way, believing themselves to be legally obliged to behave in that way. And then we say that over time, we see a principle of customary international law emerging. Now, that source of international law is important because I'm going to be talking about a key principle of customary international law in relation to the status of the territory of Israel. Before we get on to that, just to clarify a big misconception. especially in terms of the debate about international law in Israel. And that is this idea that UN resolutions have legal force. Now, these are, for the vast majority, political tools as opposed to legal ones. Resolutions of the General Assembly have no legal force whatsoever. They are purely political. Resolutions of the Security Council are, for the most part, also entirely political. The legal status of a UN Security Council resolution is determined by the chapter of the UN Charter under which it's made, and the vast majority are not made to be legally binding simply because, diplomatically, politically speaking, it's much easier to pass a resolution that doesn't have legal teeth. In order for a UN Security Council resolution to be legally binding, it has to be passed under Chapter 7 of the UN Charter. And these are incredibly rare. Such a resolution is immediately binding on all member states. They often require military intervention. And I'll give you just a couple of examples. Resolution 678 in 1990, with respect to Iraq, the Security Council gave Iraq a set period to withdraw from Kuwait, and it empowered states to use all necessary means to force Iraq out of Kuwait after the deadline. And Security Council Resolution 1373 in response to the 9/11 attacks, that was famously made under that Chapter 7 rubric, so as to be binding on all member states. But if a resolution isn't made under Chapter 7, it's automatically made under Chapter 6 of the UN Charter. And those resolutions, unless they meet very specific criteria, which classes them as decisions, they simply don't have legal force. And it's something to bear in mind, I think, when you're discussing international law in relation to Israel. Now, the essence of this talk is the status of the territory in international law. And as I indicated, there is a fundamental principle of customary international law that establishes the borders of newly emerging states at the moment of independence. So, in Israel's case, in 1948. It's a universally applied principle. It developed throughout the 19th century. It was applied in South America. It was later applied in Asia and in Africa, and still later at the disintegration of the former communist federations. And it's been applying to all of the states that emerged in these cases, and also crucially to states emerging from former mandates. For example, the mandate for Mesopotamia when it became the Kingdom of Iraq, mandates for Syria and Lebanon, and really in all cases involving mandates, this was the default rule for those states emerging in terms of what their borders would look like. Now, this universal rule for determining these borders applies at the moment of independence, at the critical date of independence. And when the International Court of Justice talked about this principle, it talked about it in terms of a photograph of the territory at the critical date of independence, and that determines the international boundaries according to the pre-existing administrative boundaries of the entity that this state is born from. The rule is called uti possidetis iuris, and it's a default rule, so it applies where there's no agreement to the contrary. It's been applied and it developed to afford certainty in situations where matters can be uncertain when new states are coming to existence. It was applied to avoid frontiers being challenged by neighbouring states, to avoid wars breaking out, and to promote peace and security. Those are the reasons the International Court of Justice recognised as being behind the development of this principle. Now, another fundamental principle of international law is its equal application. You cannot have a general rule and an exception for a country that you just don't like very much, or you have some political or ideological opposition to. That is not how any respectable legal system can operate. So the question must be, why does this principle, universally applied, or in fact, what does this principle universally applied tell us about the legal status of the territory in Israel's case? And if it's not being applied, why not? So, firstly, what does it tell us? Well, in 1948, the administrative lines of the eastern side of the British Mandate ran along the Jordan River, and I'm going to beg your indulgence for a moment while I share my screen to be able to show you exactly what it is that I'm talking about. Because here we have the British Mandate after the severance of Transjordan, and this was the eastern border that you can see, the Jordan River running all of the way down to the Red Sea in the south. This was the landmass, the British Mandate for Palestine, that the State of Israel emerged from. And the question the principle tells us to ask is how many states emerged from this territory at the critical date of independence. And if the answer is that in 1948 it was only the State of Israel that declared independence, then the principle tells us that Israel inherits the pre-existing lines of the British Mandate as its internationally recognised borders. And now I can, I hope, stop my screen share. So that was the line originally dividing the mandate from the separate administrative unit of Transjordan. It later became the Hashemite Kingdom of Jordan. And by the way, Jordan's borders also followed the principle of uti possidetis juris when it came into existence. Now, Israel, as I indicated, is the only state to emerge from that territory in 1948, automatically assumes under this principle, as its internationally recognized borders, the administrative lines of the mandate. And as you saw on the map, that includes East Jerusalem and the West Bank, which was occupied by Jordan between 1948 and 1967. These same areas were recovered by Israel in 1967. The legal status of the territory, therefore, applying this principle, is that Israel has been sovereign there since 1948. There has been no agreement of any kind on the transfer of sovereignty, and just remember that this principle applies as the default where there has been no agreement. The legal status is important because it tells us that Israel's presence in the territory is entirely lawful. And crucially, it is not a situation of occupation. That is another misrepresentation. The framework of the law of occupation developed in customary international law not to protect the